And we welcome in studio Tsepo Khadima, a political analyst. Udov Khoza is an independent political analyst. And you're most welcome to join us on all social media platforms. Good evening, gentlemen, and thanks so much for joining us. While there's a review in place, there's a court process. Is it right then for the Democratic Alliance to almost, want to circumvent the conclusion of that process? Tsepo?
Look, the Democratic Alliance course of action is untenable, legally so, on two fronts. The first front being on they have not explained the Superior Courts Act provision, particularly when there are reviews, a review or an appeal. It's exactly the same thing, taking into account what the Constitutional Court, the status that they've since accorded to the Office of the Public Protector last year during the Nkandla judgment. So therefore, this review would fall well within the Superior Courts Act provisions, but also in terms of the uniform rules of the High Court. I think it's Rule 49. I'm made to understand that it has been amended, but I think it does apply in particularly this the Gauteng High Court, that Rule 49. Certainly, I can't see how legally they can hold courts in that regard. But also, on the other hand, of course, it is not just a simple matter of saying, look, it doesn't matter because you have not specifically interdicted the public protector as remedial action, and therefore you must implement it. Because here we are dealing with constitutional provision, and there can be nothing to be read into Section 84 other than that it is the president's prerogative solely. There can be no other. And I think it is for that reason that it should not surprise us that Chief Justice Mogoeng has not raised his hand up to say, by the way, the public protector has ordered that I appoint a judge, and hereby I'm appointing a judge within that specified period, purely for one simple reason. The courts don't make the laws. The courts interpret the laws. The Constitution is the supreme law of the land. There can be nothing read into other than what is provided for. And also in terms of the 1947 Commissions Act, there is absolutely nothing that can deviate or take away the powers of appointing the chair of the Judicial Commission in the form of a judge, as currently I think the DA is trying to argue. I can't see how they will hold courts. I think they are going to sink.
Yeah, two things. The public protector's findings or remedial action are binding. Secondly, the preamble to that remedial action was that the president is conflicted or compromised, is implicated in the state of capture report. Therefore, he cannot be objective to appoint somebody who's not placid, who's not.
There's no finding against the president. The president was never. There wasn't any findings or any specific remedial action against him. That's number one. Number two, he's performing a administrative function. So that whole concept that he can't be a judge and a jury in his own matter, it doesn't hold water because it's administrative. I mean, what does that mean? All the judges, including recently the judge of the Constitutional Court, the Deputy Chief Justice of the Constitutional Court, who have been appointed by the president, does it make them any less independent? Does it mean that when they sit in court and adjudicate on matters because they were appointed by a president that some people might not like, that they are conflicted or their status is diminished? Absolutely not. And even in fact, if anything, it brings a mockery on the judiciary, the application by the Democratic Alliance, because it means, therefore, that the justice who will be a judge, their character in this case is not something that we can be able to rely on, and they haven't advanced any reasons as to why such a justice who would be appointed to then head such a commission. But if anything, and finally, what I'm reading here, it is nothing other than mischief making by the Democratic Alliance, because it serves their backers, in whatever form those backers might be, that there be no investigation or a judicial commission of inquiry to look into a wider broad with wider terms of reference. They want to now use the courts, put the courts in an invidious position whereby it is narrowed solely on, let's say, what was produced by the erstwhile public protector Advocate Tulima Donzela, so that the others who, if anything, have more to fear about a judicial commission of inquiry can therefore be exonerated or can walk scot-free. That will not happen. And I think they are playing politics, but it's mischief making anything else.
Yeah, your views, Udo, in how things, where we are, that the accusation is that Jacob Zuma is stalling the process, he's not wanting to implement the remedial action of the state of capture report.
All of that is nonsense. As correctly mentioned, it is mischief making. It's discrediting the courts, it's discrediting the judiciary, and the law system that we have in this country, with the apartheid past being part of it, makes it very difficult to even accept that kind of thing. To keep a nation and a government and a ruling party in court and hammer them all the time until the conference in December and then thereafter until the elections 2019 is their aim, and to hammer the ANC continuously to discredit and discredit and discredit and change the image of the ANC in the public eye on the public platform is really despicable and should never be allowed. We should not be allowed to have a power share understanding between the ruling party and the ANC-led government and the judiciary. The
judiciary but bottom line is that
the
judicial inquiry has to happen as per the binding remedial action from the Public Protector's Office. And the fact that you say there should be a wider scope into investigating state capture from time immemorial or since the history of this country is good and well. But does that mean it's subject to the judicial inquiry not taking place because we want to have a wider scope of investigation, or can this process go forward and then we tackle the other issues?
No, they can be able to run parallel. Maybe the public protector, the current public protector, I'm amazed that she did not move to amend that particular remedial action because it is unconstitutional. I cannot see how anybody can hold cause that it will be constitutionally valid for the constitutional provision itself to be amended by the public protector.
But she had very little room. She didn't have elbow room to
No, she has got every room. She can be able to amend that remedial action. We saw her do the same in the recent ABSA Bancorp saga with the Reserve Bank, and when it pertained to, again, the constitutional provision as to who has the duty and the power to amend the constitution, and that the public protector, can the public protector give such an instruction? And she herself has admitted that she didn't necessarily possess such powers, because what the Democratic Alliance is arguing, they are actually saying that the office of the public protector is superior to the constitution. Where that can be legally found, it's flabbergasting, because there is no such provision. The supremacy clause simply means that the constitution is the supreme law of the land. Therefore, that section 84, inherently as it is, it supports the Commissions Act of 1947. There can be no deviation. So what they could have done was to amend the remedial action to say, as far as the probe, which is called state of capture, that probe, the public protector should have amended, it would appear in my own analysis, that by amending that would have taken us out of this constitutional crisis, because then the president could go ahead and appoint, and therefore the president could duly comply with the remedial action of the public protector. But right now, the president cannot do so, because to do so will itself be in violation of the constitution, which is an even more serious offense. And even the chief justice cannot go and do that, because the chief justice cannot even he himself amend the constitution.
It's not open to discretion. In other words, if the president felt he's going to appoint the judicial inquiry, regardless of his constitutional rights being violated in terms of the instruction that was given by the public protector, can that still happen? Are you saying that he would have endorsed the state of capture report in its entirety if he had done the judicial inquiry?
He would have violated the constitution, because the remedial action as it stands, it says that, listen, the powers that you have in terms of the constitution, we are removing them from you. I just cannot see how the chief justice would have processed that remedial action, and I cannot see how the president would have, without both of them being in serious violation of the constitution, and in both instances they would have been impeached or removed from office.
What are your views on the DA saying this is justice delayed, justice denied?
Well, I can quite easily say the South African courts are used nowadays by political opposition parties to posture. This is taking chances big time, and this should actually be highlighted as well by the media. It seems that this is the final control of South Africa at the moment. The courts are being used to promote that one too. The conference in December, the elections coming in 2019, are structured to make sure that the ANC is being discredited, undermined. They say, oh, look, the courts have said this, so therefore it's legally correct, so therefore we are right. As the opposition party, we should lead the government and we should lead the country. So it's political posturing at best.
Yeah, but could the court find that, as the DA argues, that in Zuma's review application there's a loophole in that he didn't object, or rather he didn't apply for a stay of execution? Maybe you can explain the legal terminology there, as opposed to the remedial action. So what is the stay of execution that the president ought to have applied for as opposed to the review process?
Yeah, that deals with the amendment of the Uniform Rules of the High Court, which would have been Rule 49. But it is actually in conflict with the Superior Courts Act, which the courts are under obligation to have to apply. Because I am aware of the instances where they refer to the erstwhile Hawks head, General Ndlemeza, as well as in the matter of the street name change. But those two cases, by the way, are not relevant, because here we are dealing with constitutionality. And I cannot see how they are hoping that using those as case law, and also they were not even within the Supreme Court of Appeal, therefore they hold persuasive value more than as an authority in terms of the way that they are approaching it. And certainly I think this is not the end. If anything, should the High Court in North Gauteng High Court in Pretoria, agree with the Democratic Alliance, I cannot see how the Supreme Court of Appeal or even the Constitutional Court would believe that indeed it is warranted, as I say, to do so. It would plunge us into a constitutional crisis. Now, I've listened to the thing. I think the President's Council quite correctly are arguing that the Constitution is very specific. There can be nothing read in terms of interpretation into Section 84 other than what it really is. And that is that it is the President who appoints the commissions of judicial commissions of inquiry. And as I say, that simply just reinforces the Commissions Act of 1947.
So nowhere else does it say that a president has to, or rather give conditions or exemption that if he's found to be implicated in a particular matter, he therefore must recuse himself of the appointment of a judicial inquiry. Is there the
drafters of our constitutions were not psychic enough at the time when they were drafting the Constitution to foresee some of these things. The question that must be asked is, how serious is this? Is it that egregious that it stands to have the Constitution amended? And in both instances, I don't believe that it is that egregious or serious to have to even necessitate a constitutional amendment, that as matters stand today, the only way out of this impasse would have been for the public protector to have amended her report in terms of the remedial action, so that we do not have now this question mark in terms of really, is there power to be taken away from the President and be conferred upon the Chief Justice? The Chief Justice himself would not be able to do that, because to do so, if the Chief Justice was to be seduced legally and attempt to appoint the Judicial Commission of Inquiry, I can assure you the Chief Justice himself will be tomorrow impeached. And I think he understands the law. He knows the seriousness of what the DA are attempting to steer him in the direction of.
May I just quickly add here to what Tsepo said? The negotiation teams at CODESA in 1994, or up to 1994, knew exactly what they were negotiating. They knew exactly what was going to happen. In fact, our Tambo warned from the onset that this is the beginning of the end. And you could see the secret sunset clauses that were brought in to protect minority groups, and to make sure that the minority groups are completely protected, which is an emphasis of apartheid. But this was brought in by de Klerk and Joe Slovo. And the negotiation team was a very broad negotiation team on both sides, the ANC, SSCP, COSATU, on the other side the apartheid regime and its international backers. So you already had a clue then already, something is going to happen sometime. And
But the state of capture had occupied our minds and imaginations for years until it was released. And of course, the review then happened. And where we're sitting now, are you of the view that it is not in the best interest of the public to have the state of capture judicial inquiry implemented?
Depends which judges are being appointed.
Your view, sir?
Not really. I'm saying the state of capture was effectively an investigation by the public protector, lawfully so, and the remedial action that the public protector gives has to be in line with the Constitution because of the supremacy provision within our Constitution that says any law or conduct that is not consistent with the Constitution is therefore invalid. Therefore, the very remedial action that the erstwhile public protector Thuli Madonsela gave is invalid on basis of constitutionality. It is not consistent with Section 84. Therefore, it just doesn't hold water. Nobody can be able to worry about it. However, what I'm saying is this: had the current public protector, having considered the facts, then thought the best way out of the impasse would be then to go and make an amendment, or at least agree to court that the amendment be made to that specific remedial action so that it can be constitutionally in concert with what the Constitution requires. Therefore, we would not have been having this problem. But we now have this problem, and this problem will not be resolved even by the action taken by the Democratic Alliance. But once the public protector has made that ruling, there should be no one who will have a problem unless that problem, it is legally valid, that there is something that is unlawful in the remedial action that has been given. And in this case, what is contested is not on whether or not there can be a judicial inquiry. What is contested is the legality of that remedial action. And as matters stands, that remedial action, that specific one which directs us to how the Judicial Commission of Inquiry must be appointed,
why then
it is
would
unlawful.
the erstwhile advocate Thuli Madonsela then have that particular, I'll call it a loophole, if you're saying that it's unconstitutional to now direct what the president ought to do in the formation of a judicial inquiry?
Well, I think Advocate Thuli Madonsela left many things that when you look back now, you realize that perhaps maybe, she too was nothing but a bolombolo tiger.
Not only that, she really...
What's a bolombolo tiger? And he likes using that phrase. Udo?
Today's court hearing in Pietermaritzburg also showed that the courts are even used to cause splits within the ANC. You can see how judiciary is being used against the ANC to hammer the ANC, all in the build-up of the conference, the most important conference in December and the most important election in 2019. So, and if you look at the current public protector's situation, her residence was ransacked the other day. That is a warning to her, I think. And in that context, she must increase her security. So she addresses the heart of the whore, meaning that by addressing the Reserve Bank, you're touching a very raw nerve, and that needs to be protected at all times. So I think Stephen Goodson explained it quite well.
Yeah, no, we've seen now with questions around secret meetings or clandestine meetings allegedly with the presidency and the state security before the Sykes report was released. But coming back to the strength of the DA's case when it comes to the judicial inquiry, where do you feel there could be a case to argue, Tsepo?
I can't see what case they will be able to articulate more than what they said today, which itself, I cannot see how the court can agree with them. I just cannot see how that, because the courts don't make the laws. The courts don't draft the Constitution. Our Constitution is very clear as to who can make any amendment. You can't make the rules as you go by and make something that is so fundamental and that is specifically provided for in the manner in which you effect it, which is amendment to the Constitution, by now say, well, we know what the provision in the Constitution is, but for the time being we say forget about it. It's a situation you're sitting with. And I'm saying the previous public protector, having full knowledge of what the Constitution provided for, it is still flabbergasting to this day as to how she then saw it fit that she can direct the amendment of the Constitution temporarily by saying that, well, even though the president does have sole powers, well, if it is this, then what else tomorrow? Tomorrow you're going to be saying you can't appoint cabinet. We will assist you in appointing cabinet, as we saw the same Democratic Alliance attempting to get the courts involved in again, amending the constitutional provision, which once again is exceedingly clear. It's expressed. It is not something that you can say, I'm reading into the Constitution that this is what it requires.
I mean,
so I cannot see how the Democratic Alliance, I cannot see how the courts will agree with this legally untenable course of action by the Democratic Alliance, because to do so, the courts themselves will be party to throwing this country into a constitutional crisis. And I think the justices have now seen that the fact that they are being brought into a realm and a space that is not their domain, and they got their independence. To the same extent that they got their independence, they have to realize that. Remember, even the courts, when they give any order, the enforcement of such order, they are not able, they don't have the mechanisms themselves to enforce an order. They rely on another branch of the state, which is the executive, to enforce a court order. So you can't have a situation whereby they have that overreach, because to have an overreach tomorrow, the other branch of the state will also want to have a say in how the courts are run. And, well, what does that mean? You are in a constitutional crisis, it becomes a self-help situation, that's anarchy.
Well, the argument is also that the president is not acting constitutionally by not following the remedial action of the then public protector, 30 days of setting up a judicial inquiry and all of these other recommendations.
Only if such remedial action is lawful. In this case, it is unlawful. Section 84 is very clear.
So why would he then enter into something unlawful? That doesn't make sense. So but the media, as well as your academia, they now actually hammer on the ANC and the judiciary that they must understand that President Zuma has got no credibility. It starts with arts and culture. It starts on the judiciary. It started throughout the economy to create a Brazil state in this country, to get rid of Zuma and of the ANC. And people are vehemently, they're these stalwarts who everybody has a hand in that game to sink the ANC.
Yeah. And
that's clearly the judiciary is being used for that too. And it discredits it. It should be stopped to undermine the judiciary.
Yeah. And how does it play out, Tsepo, in terms of recourse, either way, on how the courts decide? If we say hypothetically the court agrees with the Democratic Alliance, there would be an appeal process. What is your view in terms of the way forward?
It will end up by the Constitutional Court, and it will be interesting. I think the Constitutional Court, if anything, has now demonstrated that they are fully aware that in many instances they are being asked to overreach, and they are realizing that in fact they have to give a clear message that they resist and detest the attempt to have them overreach in the domains that is not theirs. Because, as I say, if we continue to have the courts overreaching, we will end up with a constitutional crisis. So the constitution that we have, we might just as well throw it away, because it's the supreme law of the land. And every branch of the state is subject to the constitution. But the Democratic Alliance, absurdly, they are arguing that actually the public protector, the court somehow accorded the public protector higher status even above the constitution. And that's the manner in which they argued. I don't know how that can actually even be legally sustained.
All right, we're going to have to watch closely as the court proceedings continue. Thanks again, Tsepo Khadima, political analyst, and Udo Fruza, independent political analyst, joining us in studio. And you at home, thanks for watching. We take a quick ad break. We're back with the latest news update just after this.